Hi, everyone. It's June 23rd, 2021, Wednesday, 10 minutes of 5 p.m. Pacific time. We always come in a little bit early because we're excited to get and connect with all you are watching live on YouTube, on TikTok, on Facebook, and on LinkedIn. We're going to have our regular weekly Q&A session discussing what's going on in the immigration world, taking your questions live with general educational info, not case-specific kind of stuff. But this is a place to be to ask these questions. I've been doing it for over a year now. We're going to have a lot of questions coming in. And, one of the first questions that always comes up as people are starting to trickle in is, how long is my case going to take? Unfortunately, there's no answers to that. The situations with the embassies are dire. Hundreds and thousands of cases have been backed up, where typically it's only maybe a dozen or 2 or 3 dozen cases backed up. And so they're not moving these cases forward. They're very slowly, some embassies are processing them. So if you're outside the United States, it's slower. If you're inside the United States, sporadically cases go by fast, surprisingly. But many times it's just delays. Work permits right now, when you have an adjustment of status case, sometimes takes 8 months now. I'm getting average. So that's bad situation. But there's hope. They're redoing and rejiggering a lot of the immigration laws to make it less archaic and strict, as the Trump administration is putting it. So there's room for optimism. Thank you, all of our team for coming on regular. But with that, we're going to jump in and get your questions and just discuss U.S. immigration. See you in a sec. All right, everybody, thanks again for joining us. Before I also start this first question from Sophia, I want to let you know that if you are doing a marriage green card case, a fiance case, or plan on doing one, go to marriageimmigrationlaw.com and download the Ultimate Marriage Green Card Guide. It's a free guide, the best one out there. You download it, and you'll say, wow, this guy is truthful. You really created something for free. He's giving out to help people. You really enjoy it. Well, the first question Sophia asked, will the interview decision show up in the app? Thank you. Well, it depends on what kind of case you have. Generally, if you have an interview and a decision is made, you can go online to a website and USCIS.gov or State Department and check it out. It really depends on what kind of case you have. Is this too general a question? We need more specifics, but they should update you there. But in the end, if you're with USCIS, you'll get a paper notification. That's what you're supposed to rely on. And if you're dealing with the embassy, they're going to give a visa stamp in your passport. That's what you should rely on. But thank you for your question, Sophia. Next question is definitely me asked, can the U.S. wife's parents sponsor me for the F1 to green card? For F1 to green card. So probably not. I mean, are you saying you're on a student visa and you're married, U.S. wife's parents? Why would your wife's parents need to sponsor you? If your wife's a U.S. citizen, she would sponsor you. So the question in there has got some confusion. Please, schedule a private consultation, do it, and talk about it. Which actually reminds me, we have a free consultation giveaways. We maybe have 3 or 4 of them today. 15-minute free video consultations to generally discuss your case. What you should do is like, comment, and subscribe. In the comments, say consultation. And if you're watching live, and every 10 minutes or so, my associate will name a person that won it. And what you do is take a screenshot to prove that is your account. Email it to me at info@jqqlaw.com, and we'll set up a free consultation. But with your question, it's definitely me. It's not making sense to me. So try to reword it, and we'll get to it. Kirk and Sammy asked, F2A, waiting on interview in Jamaica, documentarily qualified June 2020. So let me break down what this means. F2A is the child or spouse of a green card holder. They're waiting for their green card. They have a petitioner who's a green card holder. DQ means documentarily qualified. That means they're going to have an interview in Jamaica, and they've uploaded all their documents to the National Visa Center. National Visa Center said it's fine. But they did that in June 2020. It's been over a year now, and they still haven't got their interview. And this is a big problem right now with these delays that I talked about at the beginning of the show, where they're not scheduling these interviews because they're primarily shut down. And that shutdown for such an extended period of time creates a huge backlog. So unfortunately, if they're not scheduling it, maybe try emailing them, see if they remember you or something like that, or if they open up. But most likely, you're just going to have to wait to see what happens. It's a terrible situation to be separated from your family for so long. And I mean, that's just these wait times kind of goes as a reminder to everyone who's asking about questions about timelines. It's hard to say how long things are going to take with these embassy closures. I don't know when they're going to open. And so when you ask, like, when's my case going to happen? Well, it depends on these factors that are unknowable. So with that, I don't have an answer other than just waiting further. Yubesh asks, hey, I filed for the U visa. The police certification got approved. what are the chances that my visa is approved? Well, Vish, I need to know everything about your case to be able to see what's going on. And I can't give you chances. It's either you meet the requirements or you don't in this kind of case. This is not there's more to a U visa, which is a person who's been a victim of serious crime, than just getting the police certification. There's a lot of background stuff. You have to document everything properly. Send it. A colleague of ours got a U visa case denied because they asked for a copy of every page in the applicant's passport, and this included the front cover, which only had a photo of it, like of a statute or something like that. And because they didn't send that front cover photo, they denied the case. So when we talk about chances, that's just not how immigration works. It's about what's going on in your case, how is it filed, and all that kind of stuff. So I wish you the best of luck in the U visa. They've kind of trying to help you out a little bit with some new rules that the administration just put forward last week. So, there's room for optimism there. But thank you for your question. KB asks, if I'm an F1 student, as a student visa holder, I have a business idea, should I apply business and how much investment is necessary? I think you're talking about, should you apply for a business visa and how much investment is necessary? Well, there's two types of investor visas, if that's what you're looking for. One is called the E2, which if you're investing in business in the United States, there's no minimum amount for the E2 visa. It just depends on if the government believes that the amount of money you're investing and have invested it, it's past tense. You got to invest the money first and apply for the visa. And how much you have on hand, what your background is. They believe you that this is going to go somewhere, or this is some small business that's fake or is going to go out of business quickly. And so it really depends on what your business is. But even before that, for an E2 visa, you have to have a passport from a country that you entered with, if you're doing change of status or just in general, that has a treaty with the United States for the E2 visa. So E2 visa, for example, Chinese people, Chinese passport holders, Indian passport holders, Brazilian, Russian, they can't do the E2 visa with the United States because those countries don't have the E2 treaty with the United States. But other countries do. Most of Europe, Japan, Australia, and parts of South America, they in Central America, they could do that and come on the E2 visa. So that's the smaller thing. And that just leaves you a visa for you to live and work and operate your business in the United States. There's an EB-5 program, which is, you invest a larger sum and you can eventually get a green card. It's a very complicated, complex program, much higher dollar amounts, and you have to create 10 full-time jobs, which is not an easy task. Now, there's a court decision this morning that lowered the fee, the initial investment out from what it was like $900,000 to 1.4 million or something like that. They brought it back down to the old numbers, which were around 500,000. I'm not sure if that's going to stay or it's going to last. What's going on? But if you're looking to do a large sum investment of your money and you can trace the source of your funds and you can invest it and create 10 full-time jobs, blah blah blah, then maybe EB-5 is for you because they get your green card as well. But there's just so much going on that we have to have a private consultation to see the details of your case, see what's appropriate there. So thank you for your question. Then it asks, can I add my 21-year-old daughter to my approved I-130? Done it. There's more information I need for that. So who is the person that petitioned for your I-130? Who was the petitioner for you, the beneficiary? And how old was your daughter? Were they a citizen or green card holder? And how old was your daughter when that started? So there's just a lot of different things we need to analyze in your case to see if it's appropriate as your daughter. Cautiously, I'm not optimistic it's going to work if she's 21, unless you're doing like a marriage case and your daughter was under 21 and your spouse is a green card holder, or your parents, a U.S. citizen, and your parent filed for your green card and your child was under 21, they filed. There has to be certain unique situations for you to do that. Alternatively, once you get your green card, you turn around and do what's called an F2B visa preference category if your daughter remains single, and that's going to take, I don't know, 7 years or 9 years. I'm not sure what the numbers are. I can't remember right now. But you really need to consult an attorney to see the details of the case to see what options are available. Thank you for your question, Dunnet. Sophia follows up. I have an asylum case, website, case status says the decision was mailed. I didn't get anything yet. So an asylum case, I don't think you could check online. They keep that information secret. And when they send a decision, historically, they would say, come in person and pick it up. But because of COVID, they backed that out. They probably mail it to you then. I don't handle a sound case anymore, so I'm not up on the latest news on it. But for a sound case, you pretty much have to wait to see before we get the hand letter, see what's in there, and hopefully get some good news. Aluari Timi asks, is it possible to file for my sister in Nigeria? She's 49 and single. How long will it take for her? Well, Aluari Timi, if you're a U.S. citizen, you can't file for a sibling. It's called an F4 preference category. It's going to take 15 to 20 years probably, so it's a long time. If you want to interested, do it at some point in life. For her to come here, you might as well get started now. But it is a time-consuming venture, and you have to be a U.S. citizen to do it. Now, if your parents are U.S. citizen, they could file a somewhat faster line, but there's just delay baked in the cake. Now, I want to remind everybody who's interested in a fiancé marriage case to download the Ultimate Marriage Green Card Guide, a free guide ebook. That's the best one you'll find out there. Just go to marriageimmigrationlaw.com and download that. You're going to find tons of information, practice questions, affidavit samples, translation certificate samples, forms that you typically need to file, all this kind of stuff. Because I see so many people doing it on their own and missing and forgetting to file a work permit request, or not filing an affidavit of support and getting the case denied for no reason. So, just go through that. It really breaks down. It's something I used to teach students in law school. I'm a professor, and I teach. I stopped teaching because it's too time consuming to be a professor. But when I was a professor, this was the basis of the book that I would teach my students that are lawyers. So check that out. And with that, let's get to the next question. Okay, Olga asks, my husband went for an interview on February 8th. I got refused for 221G. Since then, we've provided additional information. What's the longest timeline, longest they can hold his passport? Is it common for medical to expire? Need a new medical? Well, that's a really good question. Actually, let me answer this question. I'll read your question again. We did have a raffle winner before they log out or something. KBP661. Thanks for reminding me, associate. KBP6611. You won the 15-minute free consultation. Take a screenshot of the app or location that you're watching this on. Make sure your screen name is visible so I know it's really you and not some other person. And email me at info@jqklaw.com, and I will set up that free 15-minute consultation. Now, going back to the question with Olga, a 221G refusal can mean many different things in administrative processing. Here, it seems that they're asking for additional documents, which you supplied. What's the longest they could take? It could take forever. I've seen it take years. How long can they hold the passport? You can always request it back if you want to hold it until you ask it back, unless they on their own just give it back in some way, either you're approved or denied. And will the medical expire? Yeah, medical is only valid for 6 months on average. Sometimes if you have TB or something, it's only valid for 3 months. So many times people who get extended administrative processing, which is 221G, they will need to do eventually a new medical checkup and do that process again. So it's horrible. And a lot of times we have cases, take years. Eventually, you may have to file a lawsuit and say, how come this is taking so long? So 221G is a terrible situation to be in. Hopefully, since February, so that's long enough. It's like 4 months ago. It's a bad situation at 4 months. Give it 2 more months and then start talking with immigration lawyers to decide whether you should file a lawsuit or not. I'm sorry to hear that, Olga, but I wish you the best. User 95 asks, my sister was in the USA for 5 months on a visitor visa. Can she come back in August again? Well, there's no standard. So I get this question a lot. If you're here on a tourist visa, leave, how soon could you come back? There's no law for that. They're going to analyze your general circumstances. So when your sister, for example, flies back into the U.S. or comes by road, probably flies, at the airport, the Customs and Border Protection, CBP, is going to look and see her history and then ask her, like, well, why are you spending so much time in the United States? Don't you have a life back home? Don't you have work or house or kids or family or something like that? And if they're not satisfied with their answer, they're going to send her back either, with voluntary withdrawal or expedited removal. But they're going to want to say, well, how is she paying for herself? She's spending 5 months in the United States. It's not cheap in the United States. How are you able to pay for it? Are you illegally working? Or are you really going to come and stay here? Are you married to somebody going to stay and apply for a green card here? They don't want you to do that. So can she come back in August again? She could try. It's not up to me. It's up to Officer of the Border. Probably she'll be fine. But at the end of the day, they're going to analyze it on a case-by-case basis. So it's really up to that. Donna follows up. My U.S. citizen daughter filed for me before my daughter was 21. Can I add her? No. If your U.S. citizen child files for a parent, they can only file for that one parent. There's no other people included in there. So what you have to do in this kind of case is once you get your green card, you turn around and file for your daughter, F2B category. And let's see what today estimate generally of the timeline is. I'm going to look it up. What you can do is go to a website called the Visa Bulletin. And there they update these charts every month that break down generally who is getting green cards based on the time that they filed the case. Now, cases like yours where you're a U.S. citizen, you had a U.S. citizen child file for you aren't part of this. It's not considered what's called a preference category, so this chart's not there. But for you, F2B, that you're going to file for your adult daughter, they're approving cases filed, or the green cards are being issued, immigrant visas, let's say proper immigrant visa being issued for cases filed in February 2015. If you're from Mexico or the Philippines, it's much longer. But if you're from, everywhere else in the world, Cases filed in September 2015, about 6.5 years ago, are getting the green cards now. So you gotta get your green card, immediately file for your daughter. It's gonna be a while until she could get that green card, but just start sooner rather than later. Once you get your green card, get the ball rolling. Sorry for the bad news on it, but hopefully you can reunite your family soon. M. Harun asks, hi, is there any kind of investor-based immigration program being offered currently? M. Harun, I just talked about this in detail about 10 minutes ago. Go and watch this maybe on YouTube. You get to the live JQK Law Firm YouTube channel. Go back and watch it there. But I went through the basic investor programs about 5-10 minutes ago. But thank you for your question. Nisha asks, inquiry date was current and I sent an inquiry request. So apparently this was a case where there's delays and with USCIS, and they won't let you make an inquiry until they feel like enough time has passed. And according to what it said, enough time was passed with the case was pending where USCIS allowed them to make a request. So receive date July 1st to get response. What does that mean? The date was July 1st with K1 visa. It just means expect to get a response from July 1st, but they don't really abide by their own number. So it doesn't mean anything. Hopefully they'll say something. They may not. These inquiries are usually pretty worthless. Sometimes it works, but you just request it and then nothing happens, wait 30 days and ask again, or maybe contact your local congressperson to get their help to kick this can down the road, get this case moving. But these dates that you don't meet much, just try to follow up in 30 days. Artie asks, hey there, John, can a green card holder sponsor an F1 student through marriage? And does the F1 student need to maintain status until green card is approved? Well, that's a great question. Even lawyers, we have lawyer groups, this question came up a couple times in this last couple of days. Well, first off, if you're a green card holder and you marry someone who's an F1 student, you can file for the green card. Right now, the F2 category, F2A category, preference category, which is what it's called, is current, so you can immediately file for their green card. And they do not need to maintain status until the green card is approved, only until the adjustment of status application form I-485 is submitted. After that, they could drop out. It's not recommended. It's good to keep the underlying status till the end in case something bad happens. But if you have a solid case, and I don't know the detail of your case, it is possible to do that, file these cases regularly. And so that's that. Download the Ultimate Marriage Green Card Guide. Go to marriageimmigrationlaw.com. I'll give you a lot of guidance on the general process. But it is possible for a person, a student visa holder, to marry a green card holder and apply for a green card. But there's a lot more information you need to know about your finances, the F1 student's pre-immigration background, your relationship documents, all this kind of stuff. But the key is you need to maintain your status, maintain the F1 student status until the green card is approved. No, it's just up until the filing of Form I-485. After that, you don't have to maintain status. But don't violate status, but you don't have to maintain going to F1 student. You're in the period of authorized stay. You can stay here until the decision is made, but you shouldn't do any other violations like work without permission or something like that. All right, BJ asks, hi, once I get an I-140, I-140 is an application for a petition for a green card from an employer. If I go back to India, does it stay valid? Can I get a green card when my priority becomes current? Yeah, so I-140 is an application an employer gives to the government saying on a future date when it's current and things will work out, this person is going to be employed at their company. So you don't have to stay here in the meantime. You could go back to India. There's a huge backlog in India. So that's a major issue. Even if priority is current, it's going to be backlogged for the next year or two at least. But it is possible. And now I need to know all the details of your case. I don't know what's going on in your case, what kind of issues are. But in general, if an I-140 is pending, sometimes people have I-140s pending and they're living outside the U.S., not even here. So it is possible to just get the immigrant visa later. You have to do constant processing, but you don't have to stay in the United States to get your I-140. It's just most people want to. But I've been getting a lot of people from India recently contacting me asking the same thing. So there's something different going on. A lot of Indians want to go back and wait it out. I've been seeing that a lot. But Brijesh, thank you for your question. Let's see. CJ Said asks, when can I exactly apply my citizenship? Well, CJ, that question is just too broad, but I have a detailed video for this question. If you go to JQK Law Firm's YouTube page, and it's probably where you're watching right now, maybe, you could check it out there. Just type in, U.S. citizenship naturalization time or something like that, and I have like a 15 or 20-minute video breaking down the timeline process exactly. You can find your answer there. Now, quick note, a raffle winner is Ardit Kokja. Thank you, Kayla, my assistant, for mentioning the name. Ardit, take a screenshot of where you're watching this so I can see that your name is there. It's really you. and email me at info@jqklaw.com with a screenshot of that, and I'll reply with the link so you can schedule a free video consultation. Also, a reminder, I'm going to give questions about timelines, how long things are going to take, when your interview is going to happen, when your employment authorization is going to approve. I can't answer that question. I don't have enough information, and for the most part, things are just stuck or not moving forward. So I don't want to, waste valuable time trying to explain that I can't answer something for each person. So in general, for all the people asking, I don't have answers about timelines. All right, Parent Andrew, regular. Hi, Attorney Khosravi, asking for a friend. If an EB-1 petition is denied, how long before I can apply again with additional more detailed evidence? The EB-1 petition, there's 3 different types of EB-1 petitions, but you're probably asking about the EB-1A visa. That's the extraordinary ability visa. The other, with EB-C in particular, will have different kind of issues. But if you're talking about the EB-1A extraordinary ability, which is showing the government, the U.S. government, that you're one of the best in your field, and based on that, you should be able to get a green card, Form I-140 submitted with evidence. You get a denial, you could immediately turn around and refile a new one. There's no time lapse between them, but you just want to accumulate more and more evidence to have a stronger case the second time around. Now, if in the first case there was an issue, like accused you of fraud or something like that, that creates these other issues that exist. So that may be problematic and prevent you from reapplying. But on a typical case where they just said there wasn't enough evidence, well, you could turn around immediately and submit that evidence and get the ball restarted. Just want to, build it, have a good case. Deed asks, do you need to be married to a U.S. citizen or LPR green card holder to file VAWA? What if you guys were together and having a child, but he's abusing you, so you guys separated? I want to know how VAWA works. Well, Deed, this is not the good resource for VAWA. I don't file VAWA cases. If there is abuse, there's another visa called a U visa, which we talked about earlier. I don't handle those either, but I had a question about that. So if there was abuse, potentially you could request a U visa. VAWA usually have to be married. The child could maybe get a VAWA, and you can work through that. But I would suggest consulting with another firm for questions about the Violence Against Women Act. Good looking ass. I just became a U.S. citizen. Congratulations. Thank you again for your kind response to our previous live. Well, thank you so much. Glad to help. It's amazing that I was able to help people through this process, and we get a couple people every video saying this, and it's wonderful to have this resource help out. Good, congratulations on becoming a U.S. citizen. Apply for your passport just to get that as soon as possible. And hey, if you have the time, go to Google, type in JQK Law Firm, and just leave 5 stars on a Google review. You don't even have to read a comment, but it would help out just putting a 5-star there. I appreciate it. But congrats on becoming a new citizen. AZ asks, I submitted Form I-400. And there's no Form I-400. You mean N-400? Just wondering how my kids that are under 18 green cards will become citizens. Okay, so Form N-400, not I-400, is the application for naturalization, Form N-400. And that's once you become a citizen, if you have children that are green card holders in the United States under your custody, and maybe even not in the United States, well, but usually it's with your custody, they become citizens automatically. So what you do for that one is that you should file, you go and get the passport. So you go to the post office, wherever it is you want to apply for your passport, and you show your naturalization certificate, you show custody of the children, show their green cards, this and that. The rules are written on the Department of State's passport website, and you get the passports. That's a cheaper and faster way to do it. The best way to do it, though, additional to that, afterwards, is filing Form N-600. So N-400 is for citizenship application, N-600 is the application for certificate of citizenship. So that's additional paperwork that the Department of Homeland Security will have and give to you a copy as well that says they're U.S. citizens. So you want to do both is preferred. The N-600 has a lot of fees associated with this. It's going to be expensive. But first, go and get your passport, the passport office, and give the forms and proof that you're a citizen, children, green card holders. And then after that, if you wanted to, it's recommended you file Form N-600 to get their certificates of citizenship. But, we got to see what's going on with your kids, where they are, all these background kind of stuff. But probably that's how it's going to work out. Thanks for the question. Bridges follows up. Thank you so much for your answers. I appreciate your time and help people. Keep doing great work. Thank you, Bridges. I appreciate it and the good questions you had as well. God bless you as well. Thank you. Thank you so much. Dita follows up. How can I win a free consultation? Well, you like, subscribe, and leave a comment. So you say, hey, free consultation, and my great associate and assistant, Kayla, will reference somebody probably in a couple more minutes for another one. And then we have 2 more positions. I gave out 2. We'll get a 3rd and a 4th one before the half-hour mark, 5:30 Pacific time. But that's just how I do it. I should. Thanks for reminding me. I should probably remind people who are watching or new coming in who didn't hear about it first about the free consultations. RD says, thank you, John, for your answer. You're welcome. And RD, I look forward to having our free consultation. So just take a screenshot showing that it was you, so not some other person, and then we'll talk. Yauer asks, can we get an extension on 1 year OPT when pending I-485? My EAD OPT is expiring. Is there a way I can continue working or have to wait for new EAD? So, well, let me break down for those who are aware. So this person, Yauer, is a student visa holder. After they graduate for 1 year, they could do optional practical training, OPT for short, which gives them a work permit to get more job experience in the field they studied. But in this case, they also have a green card application pending. So first of all, Yauer, you got to make sure you file for an EAD with the green card application, so that comes down the road. But there is no extension of your 1 year OPT unless you're doing STEM. STEM is science, technology, engineering, and math major. And those, if you have a proper job, you could make an extension. That's how extension works. But on a basic 1 year OPT, without STEM, there's no extension. You will end up having a gap in between where you're not authorized to work until you get a new EAD. Sometimes you request an expedite of the new EAD based on the I-485, the adjustment of status green card filing, saying you're going to have severe financial loss, or if your employer is someone that, that's doing important work of national interest, for example, you can say, they need me to be there, please hurry it up. So there's some strategies you could push the issue on. But in general, there's no way to directly extend a 1 year OPT unless you're doing STEM. You just got to make sure you file the I-485 with an EAD request from I-765, and then maybe push it to be expedited. Thank you for your question. Pedro asks, can I travel back to the U.S. with an I-539 case open? It's been 6 months since I left the U.S., and it's been more than 1 year since I applied for the extension. I haven't had the decision yet mailed. You could try, but it just depends on how the border people are going to take it. If you want to really risk it, you want to have proof that you filed for the extension and you left in a timely manner, and then see what happens. Maybe you're, there's a lot of ifs and buts. So usually I tell people to get a whole new visa to be safe, but getting a new visa right now is difficult. So Pedro, there might be some issues going on, but I would say consult with an attorney in private about that. Shreya asks, what to do if you got 2 biometrics appointments and 1 notice and I haven't received yet, which I have first appointment, and another notice I got second appointment, first appointment I saw it online. Sometimes USCIS does send 2 biometric notices mistakenly. Best thing to do is to just go to both, be safe, but at least go to one. At least go to the first one, but you should probably just go to both. They mess up like this sometimes. Yauer says, thank you for your explanation. It was helpful. Thank you, Yauer. I appreciate it. Thanks for coming and finding us on the show. God bless. All right. So did we go through a lot of questions right there? We think we have a couple more popping up in a second. But, that question about OPT is a really important one. And just student visa holders in general, because I see people have problems with this because when they're applying for their student visa, they don't mention previous work history, or they're in the U.S., they do an internship without official OPT. They think it's not a big deal. The school doesn't guide them properly. And then they go exit the United States, go file for a new F1 student visa, don't mention the fact that they work with authorization or their work history. And potentially that could be a problem, or other issues for people filing for student visas, like they don't mention that they had military history or they were in the military for conscription. That's when a country forces their citizens for a year or two to do practice military training, just in case something happens, they can help mobilize the country during time of war. And that conscription has to be mentioned in the Form DS-160 for the F1 student visa and all visas in general. And frequently I find student visa holders in particular forget to mention it, and then becomes a big problem. So I definitely recommend being very thorough, answering every question. If you're confused, talk with an immigration attorney to help you through it. Seeing the disasters come up later is heart-wrenching, so I really don't want that to happen to you. So I think we have a new case. Nadig says, you skipped my question. What was the question? Maybe I skipped on purpose, Nadig. I don't know. Let's see. I can't find it right now. So Nadig, just ask your question again. I don't see it anywhere popping up in my queue where I'm going back right now. So just ask your question again. Shreya Krishna says, so I have to go both appointments. It's better to follow the instructions that USCIS gave you. You should do both. Just to be safe, but at least do the very first one so that they get your fingerprints in the system. You don't want to deny your case for lack of fingerprints or something like that. So if you could, just do both. Why take the risk? I know it's annoying, but just go by it. I have clients who couldn't make the second one. I've told them not to, but I don't know your case individually to give you that kind of advice that could be consequences to your case. So I'm not giving you that advice, but that's that. Done it at, okay, Tony asks, average biometrics appointment days after filing for marriage adjustment in San Diego. There are no average times, Tony. I have a San Diego case. Let me see when the last one came. I don't have to look it up, but there are no average times. Sometimes it's 2 or 3 months. Sometimes it's 6 to 8 months. So don't look for any average times for cases. Clients always want this, so I give them a general number, but the immigration department is so inconsistent that it's very difficult to answer that question. Now, Nadia asked, well, I'm going to answer a question. There's no question here. My associate and I both looked through our list. They never asked the question. And Tony as well. I don't know what's going on. Tony said, I skipped you as well. We just saw a question now. Actually, I see a previous one here, but Nadia, we didn't have that one. Donit asked, thanks for your question. It says, thanks for your answer to my question, but you skipped my last question. Donit, I don't know. I think the software is having some sort of issue. I think there's probably a gap or something like that where some questions went missing because your second question on it is not there. So please just ask it again, and we'll see what's going on. Actually, Donna, was your second question about your daughter being a U.S. citizen? And I answered that like in a 5-minute question. So if that was your one, I answered. Just go back and listen to the video. All right. So Brijesh asked, extending my question on the I-140. To get a green card, I need to come back to U.S. on a H-1 visa again. What if an employer offers me an H-1 visa? No, for an I-140, there's no come back to this when you come back to the United States with an immigrant visa to get your green card. All right, so we're wrapping up pretty soon. You know, I want to name our winner, Didi Hirsch. You are a raffle winner. So if you are still watching, take a screenshot of the location you're watching this, so it includes to show your screen name, your username, so I know it's you, and email that to me at info@jqqlaw.com. There, I'll take your email, reply to it, and give you a link to schedule a private video consultation so we can talk 15 minutes, see what's going on with your case. So thank you. I also want to remind you about the Ultimate Marriage Green Card Guide. If you're interested in a fiance or marriage case, go to marriageimmigrationlaw.com, marriageimmigrationlaw.com, and download the best ebook out there. It's free. That really breaks down the process, can help you well. All right, one of our last questions, Sholas. I'm in India. Can I apply for fresh H-1B now from India? I mean, you can always file for an H-1B if you haven't I-129 for an H-1B approved, and then go. If you have a job lined up, you could try. Getting appointments are hard right now, so there's a whole mess of other practical issues in India. But can you apply? I just don't know enough information about you individually to say yes or no because I don't know anything about your case. But I wish you the best and hope you get it. All right, Don asks, what happens when you have 2 I-485s and one is approved? Well, then the other one gets voided because you have an approved green card. So that's that. It's 29 Super C, a regular. Says, good night, Attorney Khosravi, saying hi and hope you're doing well. Thank you, 29 Super C, a regular of ours. 29 Super C, where are you located and why so interested in immigration law? I'm always interested. You're always here, and I appreciate coming and asking good questions. But let me know more about you. What town are you in? What city are you in? And what is your specific interest in immigration? Do you have a case pending or just general, you're interested in this immigration stuff? All right, so we're gonna be wrapping things up. On wait for 29 Super C is still there to answer our question, but I wanna thank everyone who joined us. We do this every Wednesday, 5 p.m. Pacific time, usually getting sooner like we did today. And we have free raffles, 3 to 4 free video consultations about this process. 29 Super C response now from Trinidad Tobago. 29 Super C, have we had a consultation with a couple from Trinidad Tobago about a month ago? Is that you? You don't have to say your real name, but was it you that we had a consultation? And I appreciate it. I have a case pending, so it wasn't you, but great, that's your case pending. Hopefully it gets done faster. Things are going real slow. So I think with that, I want to thank everyone who joined us today. I appreciate you coming on the live show with your questions. I'm here every Wednesday, 5 p.m. Pacific. If you want to schedule a private one-on-one consultation, email my office, describe briefly what your immigration issue is, and if it's something my office handles, we'll give you more information about scheduling a time. Please do apply for consultations, but we'll discuss it at that time. With that, everyone, God bless, be safe, and I'll see you all next week. Bye-bye.